I am broadcasting this on our company Facebook page, as well as we're going to record this and post it on our YouTube channel later. This is a training primarily intended for our growing family of realtors, but you're welcome to join in and post questions. On the Facebook live feed, you have the ability to post comments and questions as well. And while I will not be looking at that during the session while we're going through the contracts and so forth, I will absolutely look at the comments and go through it before we wrap up the session at the end here today. Now, my name is Thomas Hyman. I'm the founder and CEO and primary broker for Realty Partners, the agent-owned company. And I run into this situation all the time where agents are joining our firm coming from other companies or dealing with new agents, inexperienced agents that really have some misunderstandings about what is part of the contract, what needs to be in the contract, what's the difference between a traditional contract and an as-is contract, all of the additional addenda and disclosures that are listed at the end of the contract. Where do they need to go? What is really part of the contract and what's not? When can people sign? When can people initial? And it really creates a lot of issues when you have a situation, for example, where a document is referenced in the contract itself, but then it's not part of the package, and the agents realize 10 days later, oops, we forgot something, and now let's go ahead and have everyone initial off on it. And of course, if the effective date of the contract is purported to be June 1st, and everyone is initialing and signing off on documents on June 15th, then that technically makes June 15th the actual effective date of the contract. So we want to avoid any of these kind of challenges or problems that can ensue from this. We also are utilizing DotLoop, which is an amazing transaction management platform. And I want to give you guys an overview on how easy it is to create a contract using DotLoop and how to go about presenting a contract or an offer in DotLoop. And I want to make the first distinction right here. And a lot of agents made that mistake, and I make that mistake myself sometimes, is in confusing key terms like customer versus client. Everyone talks about their clients when in reality, 99.9% of the time, they're working as a transaction broker and it's not their client, it's their customer. Huge, huge, huge distinction. Likewise, contract versus offer. When I am working with a buyer and I have my buyer sign the document, it may be the contract form, but it's not a contract. I'm not sending the other agent a contract. What I'm sending them is an offer. It's not a contract until everyone has agreed to the terms of the contract. So just make sure you don't mix up those two, because you're talking about a contract when there is no contract. That also can be quite confusing and cause some issues. And then also realize who is party to the agreement. And I created a separate training, which I'm going to link to in the comments. I did it a while back. It's on our YouTube channel, but it's called The Four Corners of the Real Estate Transaction or Contract. And when we're looking at the sale and purchase agreement, understand that this is an agreement only between the buyer and the seller. So the broker is not party to that agreement. The broker is referenced as the person that procured the transaction, but the broker is not party to the agreement. And so you cannot use that contract to renegotiate compensation, fees, et cetera, et cetera. So let's take a look at it. And again, we use DotLoop, and I went ahead and logged into my personal profile. So I'm going to pretend like I'm an agent, and I'm going to go ahead and start a transaction. And what I did is I picked a listing, an active listing from one of our agents. And so here is 12809 Daisy Place in Bradenton, Florida 34212. And so that is the property that we're going to write a mock offer on. And when you look here in your matrix MLS, you have, you know, all these little tabs up here. This one is an important one. If your agent is diligent, then you will find all sorts of documents added in here. And a very, very important one, of course, is this seller's disclosure statement, the seller's property disclosure. And if we don't have that, if we're working as an agent for the buyer, then the first thing we ought to do is pick up the phone, call the listing agent and say, hey, I have you know, a buyer here. We're looking to write an offer on your listing. Can you please email me your seller's property disclosure? I looked in the MLS and it's not there, okay? And now very important, understand that the seller's property disclosure is generally not part of the contract unless it is referenced, you know, unless it's incorporated by reference. And we'll get to that when we go through the contract itself. It's a disclosure statement. And, you know, by law, the seller is required to disclose any known facts that may materially affect the value of the property, any hidden defects and so forth. And the seller's property disclosure statement really is a document that was created to just formalize that disclosure so the buyer can't say, oh, I wasn't told. And as you know, everything has to be in writing when it comes to real estate. And so that's why that document was created, but it is a disclosure. It's not an addendum to the contract. It's not part of the contract unless it is incorporated into the contract by specific reference. But we do want it, and in 99% of all cases, there is a disclosure statement. So let's get it and download it. I went ahead and downloaded it already. So let's get started. So looking here at DotLoop, we start by creating a loop, and we want to use the address as the name for the loop. And I'm just going to go ahead and highlight the address here. That should work. I'm going to go ahead and create a loop. I'm going to go ahead and paste the address in here. And actually, I want to show you something. If I go ahead and start to type in here, you're going to see that DotLoop will present me with the property, and it could be from Google Maps, it could be pulled out of Zillow, it could be pulled out of the MLS. I'm going to take it, I'm going to click on it because that will, you know, spare me from having to re-enter the address information. And then I'm going to select a template, and it's going to purchase buyer is going to be the template that we're going to use, and I'm going to create a loop. And so this is going to create a template that includes a whole bunch of documents, many of which are not required. So I'm going to look here at matrix. When was this built? 2006. So obviously I don't need the lead-based paint pamphlet. So I could actually just go ahead and remove it. And the way we remove it is basically just archive it, okay? And you can always show it again if you click on Show Archive, but we're going to remove it. And we also don't need this lead-based paint disclosure, so I'm going to archive it. Now, it's not a condominium. We don't need the condominium receipt or disclosure, but I'm going to leave it here right now because I want to go through it. And actually, come to think of it, let me go ahead and pull back the lead-based paint disclosure as well, and I'm going to archive it because I want to go through this. So the first thing I'm going to do is I'm going to go through some of these documents with you, and then we'll go ahead and write up an offer so you see how easy that process is. So I'm going to keep the best to last to make sure that you're actually going to stick around and stay with me as we're going through this session. So let's take a look at these documents. Buyer Real Property Info and Agreement. This is a document that we use internally, and when you click on it, it opens it up, and it's going to pop up here immediately an autofill for the roles. These are the roles that are in that document, okay? And I'm just going to skip this here right now, but when we get to our contract that we're going to use, I will not skip it and specify the roles at that point. But right now, I'm just going to go ahead and look at the documents except for the as-is contract, because we're going to use the as-is contract to do our sample document. So there are two places for a buyer to sign, which is why there is the buyer role defined. And this is just a disclosure document that is a cover our but document from the brokers and agents perspective. We pointed out a bunch of key things to the buyer. The buyer cannot say, oops, I wasn't told, okay? And down here, normally our agents charge a $395 flat fee compensation. So our compensation is 3% plus $395. If 3% is what's in a co-broke. We have another document that does not have the compensation, and you can add that document. If you click here on Add Document and go to Templates, and you go here to Buying Documents, you can see here and you hover over it. Here's the Buyer Info Agreement PDF, and down here is another one that says no fee, so this one does not have a fee in there. And you could just tick this box and then copy it into the transaction. This one here we're going to skip for right now. Let's take a look at this addendum to contract. This is just a blank addendum statement that you can use if you need to write up an addendum after the fact, if something needs to be added. Energy brochure should be provided to all of your buyers. Now here we have the contract for residential sale and purchase, and we will open this one. And here too, just as with the as-is contract, you see all these roles. We haven't defined any roles yet. We'll get to that next. But if you look at the property address, it already brought it in. We don't have to re-enter that because we selected the property from the option that was given to us. It even puts the county in here. So this is a regular standard contract for residential sale and purchase. You know, when I first got involved in real estate, 2003, 2004, 95%, if not more, of all the contracts that were written were standard residential sale and purchase contracts. And the as-is contract was quite rare. Sometimes we used an as-is addendum to the contract if we wanted to ensure that it was an as-is deal, so to speak, without any repair requirements. Very rarely was an as-is contract used, and it really just happened with investors. So this is the contract that was used. Now, when the market crashed, 2008, 2009, 2010, everything went to hell in a handbasket, and for a long time, almost every single transaction out there was either a short sale or a bank-owned REO. And so the lenders dictated that you had to use an as-is contract during that time because they did not want to be involved in any repairs or any kind of warranties or guarantees. So the lenders dictated that you have to use an as-is contract. And because so many transactions, I mean, almost 100% of the transactions in some areas for a few years, and then still for a very long time, 75%, then 50%, then 40% of the transactions, I would say from 2008 through 2014, the bulk were distressed sales, short sales, and bank-owned REO sales. And so everyone got conditioned to use the as-is contract. Many of you got licensed during that time. Many of you have been licensed realtors since, maybe 2008, 2009, 2010. Some of you are newly licensed, but everyone has been conditioned to use the as-is contract. So very few people even use this, and very few people know what's in it. And so I just want to walk through it. Now, the contract, again, is between the buyer and the seller. Generally, the buyer makes an offer and the seller accepts it, or the seller counters back and then the buyer accepts it, or the buyer may counter back again and then the seller accepts it. But it's usually the buyer that will initiate the offer. Once in a blue moon, you might have a situation where, you know, a buyer and seller talk and they're interested in a property, and then, you know, the buyer might say to the seller, well, make me an offer. And so the seller might make an offer to the buyer, and then the buyer might accept it. So this does happen, and it's rare, but I've seen it happen. But, you know, one party makes the offer and the other party accepts it. So here we have the parties, the seller and the buyer. And obviously you want to make sure that you know who the seller is. And, you know, in the MLS here in Matrix, if I'm still logged in, you have, you know, some tools in here like realist property detail. You have a link to the tax records. So you can dig in who the owners of the property are. And you want to make sure that you have the right sellers. Don't just count on the name that is listed at the bottom in the MLS. And obviously you want to know who your buyers are, discuss with them. How do they want to take title? The street address, the legal description. It's always good to add some legal description in here out of the MLS. It could be just a short legal description. It does not need to be a very, very long legal description. And down here, you can see the legal. It's a short legal. It's not a long legal, but I'm just going to go ahead and copy it in here. And it's going to add it to the .loop fields. So later when we open up the contract form, it should actually have that copied over. Tax ID number, same thing. Just copy and paste it from the MLS. The purchase price, obviously the amount that the buyer is offering. The escrow agent. Now, very important, the escrow agent does not necessarily mean the title company or the company that is doing the closing agent. So there's an escrow agent, and then there's a closing agent and title company, and the escrow agent is the one holding the money. So for example, some large real estate firms still have their own escrow accounts. Most companies nowadays don't deal with escrow accounts anymore because it's a pain in the neck. You have to do a monthly escrow account reconciliation, et cetera, et cetera. So most companies like us will say, you know, make the check payable to XYZ title company or XYZ attorney. If, you know, let's say the listing agent is with a large company, Coldwell Banker, for example, a lot of offices still maintain their own escrow account, then, you know, you might put in here Coldwell Banker Real Estate and their address and phone number. Otherwise, it would be the law firm or title company that is holding the escrow deposit. So the escrow agent is the company that's holding the escrow deposit, where the buyer and seller mutually agree that this party is holding the earnest money deposit in escrow, and it's to be released only at the instructions of both parties or at closing. Most of the time, it's the same as the title company, but it could be different. Your initial deposit, you know, does it accompany the offer, or is it going to be delivered within X days? So if you write an offer on an REO, for example, on a bank-owned property, you're not going to have your deposit accompany the offer. It would be delivered later on to the escrow agent, and they're going to tell you who it's going to be paid to. But in most cases, you want to have the deposit accompany the offer and have a copy of a check. Sometimes you will deal with someone that, you know, especially with higher priced properties, might say, okay, I'm going to, you know, make a $50,000 deposit. It's going to be wired to the closing agent tomorrow. So you might put in there within 2 days to have the funds wired. And then you have additional deposits. You know, maybe when the inspection period runs out, an additional deposit is due. Total financing, very, very important. you need to put in here the dollar amount or the percentage. I've seen many transactions, contracts where the buyer's supposed to get 80% financing, but this is left blank. And so when it's left blank, there's nothing here, then that means really that the financing is for zero, okay? Because when we go further down here into the financing contingency, let's take a look. Buyer will apply for financing, blah, blah, blah. Specified in paragraph 2C at the prevailing interest rate. This here is 2C. So if nothing is in there, what are they applying for? So very important that you put that in there. Down here you see the initial fields already pre-configured from DotLoop. The closing date, when it will occur. Sometimes agents get cute and put on or before. Well, on or before doesn't mean anything. If you put in there on or before June 30th, well, guess what? The closing date for the contract is June 30th. So the on or before really has zero validity, and you might as well just leave that away. The closing date is June 30th, and the parties agree to close early. They can always close early. They can close on the 20th. There's nothing that will prevent them from doing so, but one party cannot demand that the other party closes at an earlier time. It would have to be mutually agreed to. Down here we have the closing procedure and the costs. So it spells out what the seller is paying for, what the buyer is paying for, and then title, evidence, and insurance. If the seller has an owner's title policy, seller will provide a copy to the buyer and title agent within 5 days of effective date. This is something that is often missed. So as a buyer agent, you want to make sure that you ask for that. Depending on how old the title policy is, it may result in a reissue credit. So the person that pays for title will save a bunch of money. But also, more importantly, if there are some title defects, most of the time, if it's a title defect that predates the last title policy. So let's say, for example, the title company now does a search and finds something that there was, an improperly executed deed previously, prior to the current owner. If there is an owner's title policy that covered that, then the next policy will rely on that. So you can avoid a lot of grief when you ensure that you get a current title insurance policy to the title agent, because they can look at that, and if there are discrepancies and if there are issues that predate that policy, they can push it back onto the prior underwriter, and the underwriters have reciprocal agreements with each other that they will do that, so they can rely on the previous underwriter's policy. Here we have, of course, who will select and pay for the title, and you will see here title agent and closing agent. Okay, so here are these terms. We have escrow agent, we have title agent, and we have closing agent. In theory, all three could be different. So you could have an escrow agent, like the broker, you can have a title agent, and you could even have a separate closing agent. So there may be situations where, let's say, the seller insists that their attorney is going to do the closing, but the buyer is getting a loan, and for whatever reason, the buyer wants to use his title company to do the loan. So the title insurance policy will be issued by the title agent, but the closing agent is really the attorney for the seller. And I've seen it happen. It doesn't happen often, but in theory, those three parties do not have to be one and the same. There's a reason why there are three parties referenced: the title agent, the closing agent, and the escrow agent. Most of the time they're the same, but they don't have to be the same. Prorations, special assessments, this is pretty standard stuff. On the special assessment side, you want to do some research on the property, especially if it's an older property that is not on sewer. Is there going to be an assessment levied, or has there already been one levied that deals with the septic replacement to connect the property to the sewer system? If it's a condominium, has there been an announcement of a special assessment that's coming down the pike? Or was there a special assessment that the seller is currently making payments on? So this here talks about that. You know, will the seller pay the assessment in full before the closing? Or is the seller going to pay till closing, the buyer picks up then? Or if it's an assessment for something that hasn't happened yet, like a roof that is going to be built in 2019, and so there'll be a special assessment in November of 2018. Obviously, it has to be disclosed, and but who's going to pay for it? Inspection period. Now, in a standard contract, inspections take on a different meaning because the buyer cannot just decide to cancel the contract. And there are advantages and disadvantages with both of those type of agreements. You know, with a standard contract, the buyer really is more committed to the deal. If there are repair items, required items that exceed the repair limit, then the seller can say, hey, I'm not going to spend that. I said I'm only going to pay up to this amount. So Mr. Buyer, you can keep, you know, you can accept the property as it is with that amount, or you can walk. The buyer, of course, has the power, though, to say, you know what, I am going to stay in the deal. I'm going to buy it, even though the repairs could be greater than the repair limit. If there are repairs to be made that match the repair limit or even exceed the repair limit, if the seller says, you know, no problem, I'm going to pay for it, then the buyer cannot back out. The buyer cannot say, oh, I don't like the fact that there was, you know, crap in the attic, or that there was, you know, a leak on the roof, or some tiles missing, whatever it might be. If the seller is willing to remedy these things and fix them, then the buyer cannot walk. Whereas with an as-is contract, the buyer can just decide for any reason at all to walk. So, you know, it really depends, and you need to look at, okay, what is a better contract? You know, a standard contract obligates the seller to make repairs up to a certain point. So if the buyer really is serious about the property, then that might work. It might be in the buyer's you know, interest. But the seller may say, well, I don't want to be responsible for any kind of repairs. Okay, no problem. You can make the repair limit 0, and then of course any repair would exceed that repair limit. But there are, you know, there's some distinct differences between those two agreements. And if you have any questions on which would be the best one to use, then I would have a conversation with the seller and just lay out side by side, here are the pros of this type of contract, here are the pros of that type of contract. And I've done a training in the past specifically on comparing those two. And I'm going to link that into the description as well. It's also on our YouTube channel. And I'm going to dig it up after we're done here with this session, because if you're not familiar with this, if you're new to this, then watch it or just listen to the YouTube video while driving, and you just might learn something new. Now, I'm not going to go through the, you know, each letter of the contract, because again, we have some training sessions on that, and I'm going to link those. I want to get down here. So here we have the sales associates information listed, and the name of the brokerage. And now here we have a long list of addenda. And this here is very significant, because these documents, if checked off, become part of the contract. So the following additional terms are included in the attached addenda and incorporated into this contract. So that means if they're not listed here and checked off, then they're not incorporated into the contract. If they are checked off, then they are. If you check off the inspections addendum here, for example, which might deal with self-inspection, the right to self-inspect as opposed to being obligated to use a licensed party to do the inspections, and you don't include that document, then something is missing. It's like leaving out 2 pages of the contract. What happens when you have this 9-page contract here and you just leave page 7 and 8 out? Does that make a valid contract if only 2/3 of the pages are submitted? The answer, of course, is no. And so you want to make sure that these things are included because they are part of the contract, just as any of the other pages of the contract included. And so very, very important. Don't have other pages that are not listed here, and don't have things here checked off and listed and then not included in your contract document. Here we have additional terms. So this is where you would put in additional things such as buyer to contribute up to 3% towards sellers' prepaids and closing costs, or closing costs and prepaids. Very important, you want to word it in a up to $X or up to X% towards, not sellers, sorry, buyers' closing costs and prepaids and other expenses, because many times the closing costs will be less. So if you have a situation where you have a $300,000 property and it says seller to contribute up to 3% towards buyer's closing costs, which would be up to $9,000, and now the closing costs are only $3,500, the buyer thinks they're going to get $9,000, but no, they're only going to get $3,500 because that's what the contract says. And many times you have a smart seller, they're banking on that. It's like, well, let's see how the closing costs are going to be that much. Well, prepayment of insurance for a year, things like that, those are not closing costs. Those are prepaids or any other expenses. So you want to use the right terms in here. And we'll type it into the sample contract that we're going to work up. And then we have the time frame during which the seller can accept the contract. So that's this one here. Hold on. We're going to get this one here to this one here in a second. Down here we have some condominium association disclosure rider, an HOA association, and a condo receipt. These documents here obviously only apply if there's a homeowners association or a condominium. This rider here is often missed. So many times we have a situation where a condominium disclosure is provided, which is really like a seller's property disclosure that states that there is a condominium, but this rider here is missing. And this is really something that should be executed by the seller first and then provided to the buyer, because the buyer may not have all the information to fill this out. And if your seller, the listing agent, doesn't have this document, then you're in a little bit of a pickle, because you basically have to either provide the document to the seller, which then the seller has to complete it, sign off, and sometimes then you may have to have the buyer sign off on it again, and it's really difficult for the buyer to sign something before the seller actually has completed the thing. If you just sent this blank document to the seller and have the buyer sign it, that would be like sending a blank contract to the seller and have the buyer sign it and the seller just puts in what they want. So if you run into that situation, my suggestion is provide this document to the seller, because if you go forth and back 17 times when you say, well, we need to get the condo rider, maybe you're not thinking of the right term, you're saying the condo disclosure, and they're going to send you the condominium disclosure, or they're going to send you that addendum document or rider document that has 10 different disclosure, the comprehensive disclosure form. You want the condominium rider. And so I would submit it to the seller. I would not have the buyer sign it. I would have the seller sign it and return it with their accepted offer, which in essence makes this almost like a counter, because until the buyer signs off it, you don't have a deal, and have the seller complete it. So in the rider here, we have some information, approval. Is it required by the board? Okay. How many days do you have? Does the association have a right of first refusal, yes or no? Do the members have a right of first refusal? So these are all questions that only the seller really has the answer, or should have the answer to. And we want the seller to provide that to us, and then the buyer can decide if it's agreeable to them. The fees, what kind of fees are payable? Is there more than one association? Some areas have more than one association that fees have to be paid to. Special assessments, we talked about that earlier. So what are the upcoming assessments? Who is supposed to be paying for it? And the buyer's request for documents. Very important that the buyer requests the documents, and do not complete this here unless the buyer received the documents 3 days prior to making the offer. As you know, there's a 3-day right of rescission from the moment the documents are received. And even if you were to write an offer and the listing agent drops the documents, and let's just assume those are all the current documents that are required under law, it hasn't been 3 days. So the buyer still has 3 days right of rescission. So you don't want to waive that by signing off on it and saying that you were provided these documents 3 days prior. So the writer actually says that, there's an option. I received the documents 3 days prior. Another one here to look out for is the lead-based paint disclosure, which also, again, is a document that should be provided by the seller. Okay, so the listing agent should provide this to the seller, and then the buyer gets it, and the seller has made certain disclosures here. And one thing that is often missed is that the seller forgets to initial both of these. Okay, so the seller has to initial up here, the buyer has to initial up here, obviously. The seller has to initial both of these and select an option in both sections. And then down here, the buyer is acknowledging that they have received all of the information listed above. And the seller didn't initial this, didn't sign off on this, didn't indicate any of it, then how can the buyer down here initial it and acknowledge it? Okay. So make sure that this is done. And then over here, this here is the listing agent's initial, many times missing. I would say probably 1 out of 3 times this initial here is missing. So the licensee has informed the seller of the seller's obligations. So this is something for the listing agent to initial. And again, if you have a situation where you don't have this document, and believe me, you will run into this, where there is a listing, it was built in 1976, and there is no lead-based paint disclosure provided. So you just have to take it upon yourself to provide it and send it off to the listing agent with the offer. Don't complete it. Don't have your buyer sign it yet. Have the seller sign off on it first. Then it comes back to you. Then you have your buyer sign it, because again, you cannot have your buyer sign off on something that they haven't seen yet. So those are 2 documents, the condominium rider and the lead-based paint disclosure. And there are some others where the Seller really needs to sign it first, and then the buyer signs off on it and acknowledges it. Same thing for the property disclosure, the seller's property disclosure. You don't want to have a situation where there's an empty property disclosure and the buyer signs off on it and sends it to the seller and, hey, fill it out. I mean, that makes absolutely no sense. The seller has to complete it, fill it out, and then the buyer can look at it, see if it's acceptable. If it's acceptable, sign off on it. So just keep those things in mind. So let's get back to this property here, and we got 20 minutes left. So let's walk through writing an offer. We're going to use the as-is contract this time. So what I'm going to do is I'm going to go ahead and archive all these things that we don't need. We don't need the lead-based paint. Let's just assume that there's no HOA. Or if there is one, it's covered in the seller's property disclosure that we downloaded here. So I'm just going to go ahead and archive that. Let's just simple it down. I'm going to go ahead and get rid of this document here. So I'm just going to clean up here. This here we need. This is a mandatory document, the buyer real property info. And I'm sure if you're with a different broker, then you will probably have a similar type of document. I have this one here duplicate for whatever reason. So I'm just going to go ahead and remove one of them. I'm going to remove this one here. I'm going to remove the energy. Well, no, I'm going to leave the energy brochure because we have to provide it. I'm going to remove the standard contract. I'm going to go ahead and remove this one here. I'm going to remove this one here. I'm going to remove this one here. I'm going to remove this one here. For some reason, I had some duplicate documents in here. So, all right, so we're going to start with this here. And we also need to have the seller's property disclosure. So I'm going to add this document here and go to Browse. Instead of going to my templates, I'm going to go here, and I downloaded this document. And there it is now. So seller's disclosure. Okay. This one here is for the buyer as well. So we have those documents right now that I'm going to need to send over to my buyer to sign. And so let's take a look at this. Property address again, we already entered that, so we don't have to deal with that anymore. Up here, loop status, right now it's pre-offer. You know, it's not under contract yet, so we're going to make sure we put that in there. You could click on View Details and then enter all the detailed information, but I'm going to do that when I start here with this contract. So the contract here, it puts in here select persons. Now there are two ways to add people to the transaction. One is through the Persons tab on the loop, and the other one is through here. So I'm just going to do it through here. In reality, you would want to do it through the Persons tab, which I'm going to show you in a minute, in the loop, and then all of these fields will already be pre-populated. But let's say here the buyer. So the buyer is going to be, I'm going to create a buyer. I'm just going to call him Jimmy Buyer, and his address is jimmybuyer@testing.com, and he is a buyer. I'm not going to add him to my team. He's just a buyer. He's not part of my team. You could put his phone number and all the other stuff in there too. Let's just assume that there's only one buyer, and let's say the seller is, you know, Sally Seller. And I don't have an email address for her, and I'm not going to send her anything for electronic signature, so that's fine. Now, the buying agent, that would be me. So I'm selecting myself. The listing agent, let's just say the listing agent is a new person. Let's call him here Tony Lister. And you know, let's just assume that I don't even have an email address for Tony Lister. Unlikely, but what the heck? Well, let's put an email in here. TonyLister@testing.com. All right. So we got the parties here now. Escrow. All right, I'm going to select, hold on, escrow title. Select Amy Bushway here. And I'm not going to send anything to her. And we're going to kill this deal afterwards. But this is the test transaction here. Now down here we have the property information already in there. The purchase price, so this is the offer amount, and let's say we make it, you know, $495,000 for argument's sake, and let's say the earnest money deposit is $20,000, and let's say we're going to pick a closing date of June 29th, always the end of the month, make it interesting for the title person. And property includes, we'll just leave this blank right now. We can type into the contract later. Now the legal description, I thought I had that, but I guess I didn't save the last document. So I'm going to autofill here. So now this document is pre-populated, and this is an as-is contract. So you can see all the yellow stuff that's been already auto-populated here. And we got the legal in here, we got the county in here, so it's very convenient by just using the address when it pops up. And personal property included, okay, other, you know, none. And personal property is included in purchase price. There's no particular variance shall be left for the buyer. The following items are excluded. So let's say here, you know, washer and dryer. So those are excluded because they just bought it, it's brand new. And so the $20,000, let's say it accompanies the offer. Here's Amy Bushway. So we would just want to type in her address here and her phone number and fax number. She's in, and actually I selected Amy Bushway, but I should put in here Berlin Patton and Ebling PLLC, which is the full name of the title company or law firm. So you don't want to put a person in here. The escrow agent is going to be the company that is holding the money. Additional deposit, let's say we'll leave it blank. Financing. So let's say that the person is getting a loan for, you know, 50%. And then the balance to close. What I always like to type in here is just balance. You could put a dollar amount in there. So $495 minus $20,000 is $475. 50% financing, you know, $475. So that'll be $237.50 or $237,500. So you could put that in here as well. But you want to make sure that you have your numbers accurate. Okay, so this would be 50% financing. But I'm just going to put in balance because this is 50% after the deposit or before the deposit. And is my math correct? It's 7 o'clock at night now, so I'm just going to put in balance. Time for offer to accept. Let's say we want to hear from them by tomorrow. And closing date we already entered. Now here you can see already JB, the initial for the buyer to sign. So there's already the signature icon here. So I don't have to add a signature to it anymore. It's already there. When I share it with the buyer, it will automatically prompt them for a signature. I'm going to go through here. Can the buyer assign? No, may not assign. Financing, contract contingent on financing, either conventional or VA, let's just say, and or other, like seller's financing, and you know, fixed or adjustable. So you just select whatever is going to be applicable here. And I'm going to leave those two off. On the title evidence, let's say the buyer's going to designate the closing agent because they want to make sure they use their attorney and not some company that the seller is designating. Survey, so the buyer has a right to get it surveyed. Home warranty, let's say NA. Special assessment, let's say the seller is going to pay in full prior to closing. So whether the assessment is due now or due later, the seller is going to pay in full at closing. And so these are obviously all terms you need to discuss with your buyer. You don't decide those terms. You just have to really spend some time and go through this with the buyer before you write up the contract. Of course, you can, sit at a screen and go over it with them. You can do a screen share, or you can go ahead and have a printed out copy and go over it first. But you want to, discuss these terms with them ahead of time. And so, here, if there was an HOA or condo, we would check these things off. Now, sale of buyer's property, backup contract, none of this is going to apply. Now, here's something I want to point out to you. On the other contract, if you look at the standard contract, there is an option down here that says property disclosure for seller's property disclosure, okay? So that means the seller's property disclosure is incorporated into the contract. If we don't reference it, it's not part of the contract, it's just a disclosure. So if you want the seller's property disclosure to be part of the contract because of what is stated in there, then you would type it in here, just seller's property disclosure. And that incorporates it into the contract. And then here, let's say we'll put seller to contribute up to 3% of purchase price towards buyer's prepaid closing costs, prepaids, and other expenses. Bingo. So this means the buyer can choose to come up with some other expenses and the seller agrees to pay for it. So you're going to get the full 3% as opposed to just part of it. And this deals with counteroffer, of course. Right now we're working on the initial offer. And here we have already Jimmy signs here. Buyer's address for purpose of notice. Most agents leave it blank. I'll put it in there. Incorporating brokers. So obviously your brokerage. And Tony Tester, let's say he's with Remax. And so that's that. So this was the only document we could hit save and share to share it, but there's more than that to the offer. So I'm just going to hit save here. I'm going to go back. I'm going to go ahead and look at the real buyer property info and agreement. And here already now, we didn't have the signature, the name here, because we have we didn't answer the pop-up when it happens. But when you see here, it says here, can be signed by buyers, Jimmy Buyer. So they can just click on there and sign it when they get it. And I'm just going to put in here Jimmy Buyer. And you can see up here when you click on it, assigned to buyers, Jimmy Buyer. Yes, I want to save. the seller's disclosure. Now this is a little bit different because we uploaded a PDF file. So this is a seller's property disclosure. And so there are no fill-in spaces from DotLoop, so we need to manually add it. So we're going to go here, add initial. Okay, and then it says assign field, and we want to assign it to Jimmy Buyer. And you see JB. And we'll go down here to the next one, add initial to the buyer, assign field, and Jimmy Buyer. Add initial. Now when you click on here, with the add initial, there's an option you assign now. So if you had to sign something as an agent, you can just apply a signature right then and there. But obviously this is for the buyer to sign. So we'll put Jimmy Buyer. And then here we are going to put add signature. Voila. And assign field to Jimmy Buyer. And you can print the name. So you can go in here where it says add name. Okay. Drag it out a little bit. And you can actually assign it to Jimmy Buyer right here. So it's going to put his name in there. You don't have to type anything. And you could add a date here, but since the electronic signature will have the date, that's going to be fine. So we'll go ahead and hit save. And then we have the energy brochure. Let's take a look at that. It's just a PDF. And so this is just something that we have to provide to our buyer. Most people don't, but you should. So those are the documents here that we need to now send off to the buyer or buyers to sign. And so what we're going to do is we're going to go ahead and check off these boxes here in front of it. So we got this document, this document, this document, and this document. And then we'll go here where it says share. You could also fax it to someone. You could download it to something else, but just click here to share. And right now, we're just going to go ahead and share it to Jimmy. Okay? We're not going to send it to someone else. We're not going to send it to the listing agent yet because Jimmy hasn't signed it yet. Once we get a notification back that Jimmy signed it, then we'll send it on to the listing agent. And over here in DotLoop, you actually have some options. You can actually go ahead and can fill and sign or edit. So they could make changes, but I would just leave it here on can sign. And then you can also have it attached as a PDF to the email as well, but you don't have to. You can just have it shared to them, and you just go ahead and hit the share button, and it is going to go ahead and forward it to Jimmy. So I'm just going to send it. Obviously, we used a dummy email address, but you can see here now waiting on others. So the document is waiting on others. And once it comes back, it's signed, then you go through the same process again, and this time you send it on to the listing agent. And if you have a transaction coordinator, you might want to send it to them as well. It's totally up to how you set up your business process. And then when you get it back, because right now it's just an offer, when it comes back executed, you upload it, and then you would go ahead and submit it for review, and the document gets reviewed. So let me go ahead and take a look at some of the questions. So we have one question here where Clyde is asking, if the seller identifies an escrow agent, does the buyer have to use that agent? Well, the buyer and seller have to both agree who they're going to use as an escrow agent. Remember that the role of an escrow agent is regulated by law. If the seller is going to pay for title, and the seller says, I want, Berlin Patent or Fidelity or whoever the hell to be the title agent, the closing agent, and want them to be the escrow agent, no problem. Then just put it in there. There's no reason to fight about it, and it's much easier than having XYZ law firm listed as the escrow agent. Then they have to transfer it over to the person that is going to do the closing. Now, if the buyer is going to pay for title, the buyer selects the closing agent, and the seller says, I want to have the deposit held by blah, blah, blah escrow agent, then I would challenge it. I would honestly have a conversation with the listing agent, would say, what's going on here, because this doesn't make any sense. First of all, the buyer should be able, they're the ones making the offer, they should be able to pick whoever they want initially to be the escrow agent, but ultimately both parties together have to agree. I mean, the seller could counter back and say, okay, I want XYZ company to be the escrow agent, and the buyer could say yes or no. But, just get it out. It's going to be very, very rarely that happens. Usually, you're going to get that request if the seller is going to pay for title. Remember, if the seller is going to pay for title, then the seller has the right to pick. Whoever pays gets to pick. And so if the seller decides that, I'm going to pay for title and I want to use Sunbelt Title, then absolutely, have Sunbelt Title be the escrow agent and have the money sent to Sunbelt Title. There's absolutely no difference legally who is holding the money, because the escrow money can only be released either at closing or when both parties agree. So if both parties do not agree and there's an escrow dispute, it'll be handled the same way regardless of who is holding the earnest money. Just want to make sure it's a licensed title company or an attorney. Those are the only two parties, in addition to a real estate brokerage escrow account, that can hold the escrow deposit. All right, if you have any other questions, please post them now. Let me go ahead and hop over onto the Facebook newsfeed. I'm going to stop sharing the screen here so we don't have an eternal mirroring of my screen here. And so let me take a look here if there's anyone that posted any questions. Does not look like anyone posted a comment. Well, I want to thank you for tuning in and joining at the session. And if you have any questions, even if you're not a Realty Partners agent, feel free to drop me a line. You can post a comment on the video on Facebook. You can go ahead and just send me a message. My email address is Thomas, THOMAS, at realty-partners.com. And I've been a licensed real estate broker now for 13 years. I've also been a licensed title agent for 8-9 years. So I think I've seen a lot of different scenarios and a lot of different transactions. If you have questions, feel free to fire it at me. And obviously, I will not give legal advice. If it's something where you should talk to an attorney, I'm going to tell you, talk to an attorney. And obviously, if you're a real estate agent with another company, hopefully your broker will be there to advise you, and they will have an attorney if need be. But if you need help, or if you're just an investor or someone, a layperson, wanting to get some information, feel free to reach out to me anytime. And again, thank you so much for tuning in, and have a wonderful rest of the week.